This video is an informative presentation about the Digital Millennium Copyright Act, digital media piracy, how Appalachian State University has taken initiative to these issues, and how it all affects you as a user of the internet service that Appalachian State provides to its end users on campus. The Digital Millennium Copyright Act, also known as the DMCA, is a piece of United States legislature that deals largely with the act of illegally sharing copyrighted digital material, including but not limited to movies, music, applications, and ebooks. It prevents uploading, downloading, and any other forms of sharing copyrighted material. Appalachian State's end users typically run into this law by the downloading of digital media through peer-to-peer programs such as LimeWire and BitTorrent. This presentation will give details about the Digital Millennium Copyright Act and related legislature, how the prosecution process works, what punishments there are, how to avoid being prosecuted by taking legal alternatives, and how Appalachian State University is involved in ensuring that the DMCA is enforced on its campus networks. First, we're going to look at the actual language of the copyright law. Here's a copy of the Digital Millennium Copyright Act of 1998. This is a U.S. Copyright Office summary, so it's not the actual law itself, but rather legal summarization. While it's dated December 1998, these laws are completely applicable today. The introduction reads, "The Digital Millennium Copyright Act, DMCA, was signed into law by President Clinton on October 28, 1998. The legislation implements two 1996 World Intellectual Property Organization treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. The DMCA also addresses a number of other significant copyright-related issues. The DMCA is divided into 5 titles. Title 1, the WIPO Copyright and Performances and Phonograms Treaties Implementation Act of 1998, implements the WIPO treaties. Title 2, the Online Copyright Infringement Liability Limitation Act, which creates limitations on the liability of online service providers for copyright infringement when engaging in certain types of activities. Title 3, the Computer Maintenance Competition Assurance Act, which creates an exemption for making a copy of a computer program by activating a computer for purposes of maintenance or repair. Title 4 contains 6 miscellaneous provisions relating to the functions of the Copyright Office, distance education, the exceptions in the Copyright Act for libraries and for making ephemeral recordings, webcasting of sound recordings on the internet, and the applicability of collective bargaining agreement obligations in the case of transfers of rights in motion pictures. Title 5, the Vessel Hull Design Protection Act, creates a new form of protection for the design of vessel hulls. The first title in the DMCA is the WIPO Treaty Implementation Act. The World Intellectual Property Organization is a specialized agency of the United Nations. In December 1996, the WIPO held a diplomatic conference in Geneva, Switzerland, during which these 2 treaties were ratified. This title takes those world treaties and adds them to the United States copyright legislature. The language reads, Title I implements the WIPO treaties. First, it makes certain technical amendments to U.S. law in order to provide appropriate references and links to the treaties. Second, it creates 2 new prohibitions of Title 17 in the U.S. Code, one on circumvention of technological measures used by copyright owners to protect their works, and one on tampering with copyright management information, and adds civil remedies and criminal penalties for violating the prohibitions. In addition, Title I requires the U.S. Copyright Office to perform 2 joint studies with the National Telecommunications and Information Administration of the Department of Commerce. This title accomplished 2 major things in U.S. copyright law. It established Section 102, based off of the treaties, which included the following modifications: the addition of the Universal Copyright Convention, the Geneva Phonograms Convention, the Berne Convention for the Protection of Literary and Artistic Works, and the WTO agreement in addition to the 2 WIPO treaties outlined earlier. The second section of Title 17 was Section 103. Often referred to as the DMCA anti-circumvention provision, it restricted the legal ability to sell, create, or distribute devices that circumvent digital rights management systems. These measures were meant to limit digital media to only the person who purchased the material. The second title, which may be the most important to this particular presentation, is the Online Copyright Infringement Liability Limitation title. This title reads, Title II of the DMCA adds a new section, Section 512, to the Copyright Act to create 4 new limitations on liability for copyright infringement by online service providers. The limitations are based on the following 4 categories of conduct by a service provider: transitory communications, system caching, storage of information on systems or networks at direction of users, and information location tools. New Section 512 also includes special rules concerning the application of these limitations to nonprofit educational institutions. This title provides a safe harbor for Internet service providers, also known as ISPs, under the conditions that they meet specific requirements. The safe harbor provided to these ISPs means that they will not be held responsible for the illegal actions of those they provide online access to, the end users. The guidelines of this title, and what this title means specifically to Appalachian State University, will be discussed in detail later in this presentation. Title III is one of the shorter titles included in the DMCA. It reads, Title III expands the existing exemption relating to computer programs in Section 117 of the Copyright Act, which allows the owner of a copy of a program to make reproductions or adaptations when necessary to use the program in conjunction with the computer. The amendment permits the owner or lessee of a computer to make or authorize the making of a copy of a computer program in the course of maintaining or repairing that computer. The exemption only permits a copy that is made automatically when a computer is activated, and only if the computer already lawfully contains an authorized copy of the program. The new copy cannot be used in any other manner and must be destroyed immediately after the maintenance or repair is completed. Next we have Title IV, which contains miscellaneous provisions included in the DMCA. The first provision is a clarification of the authority of the Copyright Office. The next is the ephemeral recordings for broadcasters. Then distance education study, an exemption for nonprofit libraries and archives, and assumption of contractual obligations upon transfers of rights in motion pictures. This title was essentially a bit of housekeeping that updated existing laws. It helped to facilitate distance education, add statutory licenses for broadcasters, and added provisions to assist libraries and motion picture copyright transfers. The final title of the DMCA actually has nothing at all to do with digital media, but it is still a very important copyright law. It reads, Title V of the DMCA, entitled the Vessel Hull Design Protection Act, adds a new Chapter 13 to Title 17 of the U.S. Code. It creates a new system for protecting original designs of certain useful articles that make the article attractive or distinctive in appearance. For purposes of this title, useful articles are limited to the hulls, including the decks, of vessels no longer than 200 feet. A design is protected under the Dmca as soon as a useful article embodying the design is made public or a registration for the design is published. Protection is lost if an application for registration is not made within 2 years after a design is first made public, but a design is not registrable if it has been made public for more than 1 year before the date of the application for registration. Once registered, protection continues for 10 years from the date protection begins. This title was created to add protection for the designs of certain boat hulls. Previously, boat hulls were not considered to be covered under existing copyright law, as they were viewed as a useful, functional article that could not be distinguished from their individual aesthetic design. However, this title clarifies that the design can and should be protected under U.S. copyright law. Obviously, the main point of the DMCA is to keep full copies of copyrighted material from being freely distributed among the public. However, what are the exceptions to this rule? The Fair Use Clause of United States copyright law, Section 107 of U.S. Title 17, states that notwithstanding the provisions of Sections 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular use is a fair use, the factors to be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. The fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. The introductory paragraph sets forth what kind of uses that copyright materials can be subject to under fair use considerations. Criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. A decision can be made with the following 4 criteria in mind. The first factor, the purpose and character of the use, is often used when copyrighted material is reimagined for research and education, when the work is the subject of review or commentary, or when the material is reimagined as a parody. To meet these requirements, the material must be transformed, not simply copied verbatim. For example, in order to parody a famous copyrighted photograph, one would be able to copy the general spirit, lighting, and composition of the original, but the work must be transformed significantly by adding new meaning, information, expression, insights, or aesthetics. These uses would be considered transformative because they imitated the original style, yet still transformed it. The second factor, the nature of the copyrighted work, takes into account the original intent of the copyrighted materials. Stanford University's Academic Information Resource website explains this by saying, because the dissemination of facts or information benefits the public, you have more leeway to copy from factual works such as biographies than you do from fictional works such as plays or novels. In addition, you will have a stronger case of fair use if you copy the material from a published work than an unpublished work. The scope of fair use is narrower for unpublished works because an author has the right to control the first public appearance of his or her expression. The third factor, the amount and substantiality of the portion taken, is fairly simple to comprehend. Generally speaking, the less one takes from a copyrighted material, the more likely it is that the copying will be allowed as fair use. Parodists are allowed to take more, as they must conjure up the original for parody, and as parodies take aim at the most recognizable parts of material. However, it is not simply excusable to parody an entire copyrighted work. For example, Weird Al Yankovic does not parody a song in its entirety without first getting the permission of the songwriter. If he parodied the entire work without permission, it likely would not be allowed under fair use laws. The final factor, the effect of the use upon the potential market for or value of the copyrighted work, deals with monetary factors. If a transformation deprives the owner of the copyright of a source of income that is rightfully theirs, it will very likely trigger a lawsuit. There are, however, original works that are completely free for the taking. These works, whether they are books, songs, movies, or other artistic materials, are categorized in one of 2 arenas: the public domain or Creative Commons. Generally, most things in the public domain were once copyrighted works that have lost their copyright because of old age. Some works did not have their copyrights renewed and so fell into the public domain, while others were simply dedicated to the public domain to begin with. Materials within the public domain are free to be used in whatever manner possible. They may be freely copied, distributed, transformed, or reappropriated in any way imaginable. The other arena that materials may be presented copyright-free is Creative Commons. Creative Commons is a non-profit organization which describes its mission via their website, creativecommons.org, as the idea of universal access to research, education, and culture is made possible by the internet, but our legal and social systems don't always allow that idea to be realized. Copyright was created long before the emergence of the internet, and we can make it hard to legally perform actions we take for granted on the network: copy, paste, edit, source, and post to the web. The default setting of copyright law requires all of these actions to have explicit permission, granted in advance, whether you're an artist, teacher, scientist, librarian, policymaker, or just a regular user. To achieve this vision of universal success, someone needed to create a public, free, and standardized infrastructure that creates a balance between the reality of the internet and the reality of copyright laws. That someone is Creative Commons. Creative Commons provides a licensing structure that allows creators of original material to let anyone use their work, often asking to simply be credited for the original creation. This sets aside the traditional all rights reserved setting that copyright law creates. Creative Commons was created specifically with freely sharing on the internet in mind, and it works to build a framework that can be accessed by anyone with clear limits on what can be done. However, if the way you are attempting to use copyrighted material cannot be applied under the fair use, public domain, or Creative Commons arenas, a license must be bought. For example, music used in a television commercial must be licensed through a clearing organization before it can be broadcast to the public. Fees vary, based largely on the amount of exposure the advertisement will receive and how popular the song is. The licensing fee for a song may range anywhere from $25,000 to $500,000 for a year's worth of use. A license must be bought from both the label and the publisher of the copyrighted material. If you are planning to host a viewing of a motion picture or television show in a public place, a license must be bought then as well. According to the Motion Picture Association of America, DVDs, Blu-ray discs, and digital video files are only licensed to be viewed in a home setting. Anything else is a violation of copyright law. In other words, you are allowed to view a movie or television series you bought or rented in a home setting with friends, but if you show that same video in a restaurant or other public place, you have violated copyright law, even if you don't charge an admittance fee. Neither the rental nor the purchase of a copy of a copyrighted work carries with it the right to publicly exhibit that work. The MPAA details that bars, restaurants, private clubs, prisons, lodges, factories, summer camps, public libraries, daycare facilities, parks, and recreation departments, churches, and non-classroom use at schools and universities are all examples of situations where a public performance license must be obtained. This legal requirement applies regardless of whether an admission fee is charged, whether the institution or organization is commercial or nonprofit, or whether a federal or state agency is involved. With all that said, however, it's rather simple to obtain a public performance license. It normally doesn't require anything other than a phone call. Fees vary, but they are generally inexpensive for small audiences, as factors include the size of the audience and how many times a particular film will be screened. The major firms that handle these types of licensing are listed here. Now, with all the computers out there pirating copyrighted digital material, how does anyone know who is breaking the law? It's very simple, really. The copyright holders can go into the cloud of downloaders and see who is currently downloading a file and who is currently uploading the file. This can be illustrated by looking at how this file sharing program works. This program can be used to share any kind of file, copyrighted or not. Here, we're downloading a copyright-free documentary. The program shows the progress of the download, how fast the download is, and what kind of files are included in the download. However, it also shows exactly who is currently downloading the file. All we have to do is go to the peers section of the program, and it will show us the IP addresses of everyone that is downloading this documentary. Not only does it show us their IP address, but it also shows us what country they are in, what program they're using to download the file, and the progress they have made. The copyright holder can look into the section of any copyrighted file and pull the IP address of those who are breaking the Dmca copyright law. The IP address of every computer is completely unique, like the street address of a house. It tells the copyright holder who is illegally downloading their file and gives them a way to stop it. Once the copyright holder establishes who is downloading their product, they send a Dmca takedown notice. This notice is not sent directly to the person who legally downloaded the file, but rather to the user's Internet Service Provider, or ISP. In the case of the Internet on campus, that ISP is Appalachian State University. You'll receive a takedown notice that looks something like this. In this example, the copyright holder is 20th Century Fox Film Corporation. The copyrighted file was a high-definition version of Rise of the Planet of the Apes, a successful film. The ISP was Charter Communications. The copyright holder passed on this file to Charter Communications, which then, in turn, passed it on to the user. This takedown notice details exactly what was downloaded, who it was downloaded from, and what procedures the copyright holder took to notify the ISP. The takedown notice also provides links to websites that may answer any questions that may arise from the reading of this document. At the bottom, the takedown notice provides evidentiary information, such as the ID of the complaint, what was downloaded, how it was downloaded, what the IP address of the computer used to download it was, and even the port on the computer which was used to download the information. In this case, the user was simply given a warning, but there may be steep fines and penalties, which we will cover later. Now we're going to go back to Title II of the Dmca. Title II is the Online Copyright Infringement Liability Limitation. This is how those ISPs, the Internet Service Providers, aren't punished for allowing their users to download copyrighted material. They're given a safe harbor, if you will. Title II reads, Title II of the DMCA adds a new section, 512, to the Copyright Act to create 4 new limitations on liability for copyright infringement by online service providers. The limitations are based on the following 4 categories of conduct by a service provider. 1. Transitory communications. 2. System caching. 3. Storage of information on systems or networks at direction of users. And 4. Information location tools. This section also includes special rules concerning the application of these limitations to nonprofit educational institutions. Each limitation entails a complete bar on monetary damages and restricts the availability of injunctive relief in various respects. Each limitation relates to a separate and distinct function, and a determination of whether a service provider qualifies for one of the limitations does not bear upon a determination of whether the provider qualifies for any of the other 3. The failure of a service provider to qualify for any of the limitations in Section 512 does not necessarily make it liable for copyright infringement. The copyright owner must still demonstrate that the provider has infringed and that the provider may still avail itself of any of the defenses, such as fair use, that are available to copyright defendants generally. In addition to limiting the liability of service providers, Title II establishes a procedure by which a copyright owner can obtain a subpoena from federal court ordering a service provider to disclose the identity of a subscriber who is allegedly engaging in infringing activities. What all of this means is that the internet service provider is not held liable for whatever activity may happen on its network. This allows the internet service providers to be protected from any sort of legal action, while still allowing for the possible prosecution of those who actually download illegal material. Because of this, Appalachian State does not monitor the internet activity of its users. By acting as an ISP and not monitoring the individual activity of everyone on campus, Appalachian State both maintains the privacy of its users and releases all responsibility in the case of illegal downloads. If the copyright holder does find that someone on Appalachian State's network is downloading things illegally, Appalachian State will be notified through a DMCA copyright notice, which is then passed on to the user. In order to maintain its status as a safe harbor, Appalachian State must pass on the DMCA copyright notice to the user who broke the law. After Appalachian State University receives a DMCA takedown notice, punishments may be doled out to the student involved. Appalachian State University has developed a 3-strike policy dealing with DMCA takedown notices for the offenders. For the first offense, it's handled with a warning and a response system where the offender is notified and asked to remove all copyrighted material from their computer. Any second offense is handled through a warning and a mandatory workshop to educate the risks of copyright infringement. The internet is cut off from the student's computer for 10 academic days. A third offense is handled by cutting off the student's computer internet access for 75 academic days and placing the student on academic probation. However, those are just the penalties for Appalachian State's campus. If the copyright holder decides to press criminal charges against the offender may be fined up to $500,000, imprisoned for 5 years, or both for a first-time offense. Repeat offenders may be fined up to $1 million, imprisoned for 10 years, or both. However, the copyright holder may choose to file a civil case. These are brought to federal district court where the court has broad authority to grant injunctive and monetary relief. In these cases, the court may simply order the offender to delete the copyrighted material. However, the court may also award actual monetary damages, any profits that were gained through the copyright infringement, and any attorney's fees. If the offender continues to break copyright rule within a 3-year period following the original judgment, the court may increase the damages that were awarded previously by up to 3 times the amount that was previously awarded. Appalachian State University hopes to raise awareness of copyright issues to both its students and to other users of the university's internet access by 3 different manners. This 3-pronged approach is required by the Higher Education Opportunity Act, and Appalachian State takes it very seriously by addressing the requirements in all 3 required venues. The first requirement is to educate students on copyright and DMCA issues. Appalachian State University does this through a variety of publications such as brochures, websites, email, and the campus newspaper that addresses the issues of peer-to-peer file sharing, the Digital Millennium Copyright Act, and other copyright infringements. The DMCA is discussed in student orientation sessions, and presentations are also given to student groups and residence halls on the subject. The second requirement is to prevent inappropriate use of peer-to-peer programs and software through the utilization of a variety of techniques to deter illegal behavior. Appalachian State University utilizes tools such as Packet Shaper and a software program called Integrity by Red Lambda. Integrity by Red Lambda detects use of peer-to-peer applications, such as BitTorrent and LimeWire, and sends email notices to users that discuss the possible ramifications of using peer-to-peer software legally, leading to copyright infringement and prosecution under the Digital Millennium Copyright Act. These programs do not look at the contents of files. As stated earlier, Appalachian State does not monitor the content of the internet activity of its end users. The third requirement is that Appalachian State must suggest alternatives for downloading programs, music, and movies. The Appalachian State website, appstate.edu, lists a web page that has an exhaustive list of alternatives to stealing copyrighted digital material. There are many alternatives to downloading music illegally. The most obvious, iTunes, allows users to download songs, albums, and music videos for low prices, typically 99 cents per song and $9.99 for an entire album. Other similar a la carte music services include the Amazon Music Store, which offers a web-based service, Rhapsody, eMusic, and Google Play. Another option for music lovers are streaming music services. Most have a free service with the option to pay a monthly fee for more features. The most popular services are Pandora and Spotify. Pandora allows the user to choose a music theme, and the service chooses music that it believes users will enjoy. The service is free, with the option of a $36 yearly subscription, which gives the user access to ad-free playback and higher quality audio. The other option is Spotify, which allows users to listen to whatever song they want at any time. The service interjects advertisements every so often in return for free playback. Users may eliminate those ads for $5 a month, or pay $10 a month for access to Spotify's mobile applications and higher quality audio, in addition to advertisement-free listening. For downloading movies, users may turn to iTunes, which offers both movie purchasing and movie rentals through its desktop application. Amazon also offers movie downloads, in addition to streaming of select movies through its Amazon Prime service. Netflix offers a wide selection of movies available for live streaming in high definition through its web service for only $7.99 a month. Hulu also offers free ad-supported playback of movies and television shows with the option of a paid service called Hulu Plus, which offers limited advertisement interruption and a greater selection of television's back catalog. All of these alternative services offer access to high-quality movies, music, and more at low prices or even free services. Best of all, it's all legal, which means that the artists still get paid for the entertainment that they've put forth, and you still get to enjoy the same high-quality entertainment that you're used to. Hopefully this presentation has given you a sense of where the boundaries lie on copyrighted materials, digital and otherwise. The Digital Millennium Copyright Act is a very important part of the United States legislature, and Appalachian State takes its involvement as an online service provider very seriously. This presentation sought to be both informative and useful by presenting the laws as they are both written and interpreted, and hopefully it has been helpful in your understanding of the laws and legislation of copyrights in the United States.